Attorneys handling traumatic brain injury cases need to protect the assets recovered on behalf of their clients and to make sure that the case settlement does not jeopardize their client's right to government benefits such as Medicaid. I am proud that our law firm was involved in one of the first cases in the nation which protected the funds of a brain injury survivor and allowed this individual to continue receiving government benefits. After all, the settlement funds we obtained as brain injury attorneys were never intended to replace these government benefits, but were intended to compensate the brain-injured individual for their pain and suffering, their disability, and for their lost wages. Since these funds, however, may be insufficient to replace government-sponsored benefits, these settlement funds and the government benefits that our clients currently receive both need protection. Many of our clients, both children and adults, are receiving Medicaid assistance, which provides both medical care and home-based assistance following a traumatic brain injury. Since Medicaid benefits are based upon the financial assets of the individual, if a case is settled and the funds are given directly to the client, then the individual will become ineligible for continued Medicaid benefits. To protect the client's assets and continue Medicaid eligibility, the funds need to be placed in what is commonly known as a special needs trust or a supplemental needs trust. Under this plan, the money is held in trust for the brain-injured individual and is administered by a trustee. The terms of the trust provide that the funds can be used for any purpose other than what Medicaid pays for. Therefore, some of the things that can be funded through the trust are medical expenses and treatment which is not covered by Medicaid, the expenses for home care attendants that are not covered by Medicaid, rehabilitation care not funded by a government program, and our clients' special living arrangements, the remodeling of their home, and the proper equipping of their home for a handicapped individual. Transportation expenses for items such as specially designed vans or wheelchairs can be obtained through the use of a special needs trust and still preserve Medicaid eligibility. Educational equipment, such as computers or special learning devices or memory aids, can be obtained through the trust. Importantly, recreational expenses for an individual's vacation or leisure travel or travel to see friends and relatives can be paid for all out of the trust. But there are very special rules that need to be followed in the creation of this trust, and it's important that your brain injury lawyer consult with other attorneys who possess the specialized knowledge necessary for the creation of this type of document. You need to know the following. First, the trust can only be created for the individual under the age of 65. Second, if Medicaid has paid money for the individual's care up to the point in time that the trust is created, then arrangements must be made with the Medicaid office to properly reimburse them for all back benefits. Third, if funds remain unspent when the person passes away, then these funds must be repaid to the Medicaid program before money can pass to the individual under their estate. So it's important that you and your lawyer understand what the trust can do, and it's important that this trust be created before your brain injury case is settled. If I can help you with your brain injury case, please feel free to call me, Michael Kaplan, toll-free at 1-866-BRAIN-LAW. You can also reach me by email at michael@brainlaw.com. And you could find more information about my practice and myself by visiting our website, www.brainlaw.com.